94%. That is the percentage of drivers who, according to research from the National Motorists Association, hand over their license the moment an officer approaches their window, before a single word has been spoken by either side. 94%. They do it automatically. They do it because they were taught to, because it feels cooperative, because it feels like the thing you do. And in doing it, before they know anything about why they were stopped, before they have put a single fact on the record, most of them hand the officer the first piece of information that shapes everything that comes next. This is not a video telling you to refuse to show your license. You are legally required to show it. In every state, that is the law. This is a video about the 4 words you say before you hand it over, and why those 4 words change the legal dynamic of everything that follows. Here is what most people do not understand about the first 60 seconds of a traffic stop. The moment those lights appear in your mirror, a legal process has begun. Not when the officer reaches your window, not when you roll down the glass. The moment the lights come on, you are being detained. Detained means held in place by the authority of law enforcement. You are not free to leave. That detention must be legally justified. The Fourth Amendment to the United States Constitution requires that any seizure, any stop, any detention be grounded in reasonable suspicion of a violation. Reasonable suspicion means specific, articulable facts, real, describable observations that a trained officer would point to in a written report. The officer pulling you over already knows what those facts are. You do not yet. And that asymmetry, that gap between what the officer knows and what you know, is where people make the mistakes that cost them the most. Because here's what happens in those first 60 seconds in the vast majority of traffic stops across this country. The officer approaches. The driver rolls down the window. The officer says nothing yet. And the driver, filling the silence, trying to seem cooperative, trying to get ahead of the situation, starts talking. I know my registration might be a little late. I was just going a little fast, I know. Is it my taillight? I have been meaning to get that fixed. Every one of those sentences is a voluntary statement made before the driver knows a single thing about the legal basis for the stop. Every one of them is an admission. Every one of them goes into the officer's report. Every one of them can be used against that driver in court. The officer said nothing. The driver built the case. And the license, handed over before a word was exchanged, confirmed the driver's identity and set the clock running on a stop whose legal foundation the driver still knows nothing about. Now here is the law, and this is the part that changes everything. You are legally required to present your driver's license, registration, and proof of insurance during a lawful traffic stop. That requirement exists in every state. It is grounded in the basic principle that operating a motor vehicle on public roads is a regulated privilege, a privilege the state grants, and the state has the authority to verify. But here is what the law does not require. It does not require you to hand over that license before you know the reason for the stop. In most states, there is no statute that says the license must be produced before the officer states the violation. The law requires that you produce it when requested. A request is different from a demand. A request is different from a documented legal assertion of why you have been stopped. And in several states, California, Illinois, and others, officers are legally encouraged, or in some cases required by departmental policy, to inform drivers of the reason for the stop as part of the stop itself. California passed Assembly Bill 2773 in 2022, which requires officers to state the reason for a stop before asking questions or requesting to search, specifically to reduce pretextual stops. Pretextual means using a minor violation as a legal excuse to investigate something else entirely. But beyond state-specific policy, here is the constitutional argument that every driver in every state carries with them, whether they know it or not. The reason for the stop is not a secret. It is the legal justification for your detention. Under the Fourth Amendment, that detention must be based on reasonable suspicion. Reasonable suspicion must be specific and articulable, meaning the officer must be able to describe it. If they cannot describe it, if they will not describe it, that gap in the record is exactly the kind of thing a defense attorney builds on. You are not asking for a secret. You are asking for the legal justification for your own detention. That is not a hostile question. That is a lawful one. And here's the one question. The 4 words that belong on your lips before your license leaves your hand. Say exactly this. What is the reason for this stop? 4 words. Calm, direct, no edge in the voice, no accusation, just a question. The most important question of any traffic stop. Here is why that question matters legally, and why most drivers never think to ask it. The Supreme Court of the United States addressed the structure of traffic stop questioning in Berkmer versus McCarty in 1984. The court established a framework that governs every traffic stop in America to this day. The ruling confirmed that roadside questioning during a routine traffic stop does not constitute custodial interrogation, the formal standard that requires Miranda warnings. Custodial interrogation means questioning someone who is in police custody in a way that is the functional equivalent of formal arrest. A routine traffic stop, the court ruled, does not meet that threshold. The circumstances are public, the detention is brief, and the coercive pressure is less than that of a station house interrogation. What this means practically: officers during a traffic stop are not required to read you Miranda rights before asking questions. You are being detained. You must comply with lawful commands, but you are not in formal custody. And the questions they ask you and the answers you give can and will be used as evidence. The Fifth Amendment still protects you. Self-incrimination means being compelled to provide evidence of your own guilt. That protection does not vanish because you are standing next to your car instead of sitting in a jail cell. But as the Supreme Court made clear in Salinas versus Texas in 2013, that protection is not automatic. You must invoke it explicitly, out loud, with words, to activate it. Which means the sequence of those first 60 seconds matters more than most drivers understand. Knowing the reason for the stop before you answer a single question gives you two things that are legally significant. First, it puts the legal justification on the record before anything else. If the reason stated by the officer is different from what appears in the police report later, that inconsistency belongs to your attorney. Second, it tells you exactly what kind of stop this is, and therefore, what the officer can legally do next. A stop for a broken taillight gives the officer authority to check your license and registration. It does not give them authority to begin an investigation into unrelated criminal activity without additional facts. Knowing the stated reason tells you where the legal boundaries are from the very first moment. Comment right now. Did you know you could ask the reason for a stop before handing over your license? Yes or no? Drop it below. I read every comment on this channel. Now, there are 3 situations where asking this question plays out very differently, and you need to know all 3. The first situation is the clean stop. The officer has a legitimate, specific reason: broken taillight, expired registration sticker, rolling stop at a sign. The officer states it clearly when you ask. In this situation, asking the question has still served its purpose. The reason is now on the record before anything else happens. Your license goes over. You provide your registration and insurance. You do not volunteer anything beyond what is requested. The stop proceeds on the officer's stated legal basis. You have framed the encounter from the first sentence. The second situation is the delayed answer. The officer deflects. I will explain in a moment, ma'am. Let me see your license first. Here is where it matters most. Do not comply with the deflection by handing over the license before you have heard the reason. You can say calmly, I will have that ready for you. Could you let me know the reason for the stop first? You are not refusing. You are sequencing. There is a legal and practical difference between refusing to produce a document and asking for the reason for your detention before you do. If the officer insists and becomes commanding, produce the license, comply. Your refusal at that point could become obstruction. But state clearly as you hand it over, I am providing my license now. I am noting that the reason for this stop has not yet been stated. That sentence puts the sequence on record, quietly, without conflict. Your attorney will want to know it was said. The third situation is the non-answer. The officer does not state a clear reason. They are vague. There was a complaint in the area. You match a description. Just a routine check. These are the situations where the legal foundation of the stop is shakiest. Routine check is not a legal basis for a traffic stop. It is not reasonable suspicion. An officer cannot pull you over without a specific, articulable reason. Just checking does not meet the Fourth Amendment threshold established in Terry versus Ohio, the 1968 Supreme Court case that defined reasonable suspicion as a standard for investigative stops. If the reason stated does not sound like a specific traffic violation or specific articulable facts pointing to criminal activity, take note. The license goes over because the law requires it. But the vague answer is now part of the record because you asked. Now here's the moment most drivers reach automatically. The moment that removes all the protection that asking the question would have built. The officer has just walked up to your window. You roll it down. Silence for 1 second. And then you speak first. Is it my registration? I know I am a little late renewing it. Was I speeding? I was trying to get home before the rain. Is something wrong with my car? Every one of those openers is a gift to the officer. Not because you are guilty, because you are providing information, context, admissions, statements, before you know anything about the legal basis for the stop. Before you know what the officer came to your window looking for. The officer came with a reason. You gave them additional material before they even asked for it. The question protects you from that reflex. Say exactly this, before your window is fully down if possible, certainly before your hand moves toward your license. What is the reason for this stop? 4 words, then silence. Let the officer answer. If the officer answers clearly, I pulled you over because your rear brake light is out. Now you know the scope of the stop. Tail light, license, registration, insurance, citation. That is the lane this stop is in. You do not volunteer anything beyond that lane. If the officer answers vaguely, there have been some incidents in this area and you fit the description. Now you know that this stop's legal foundation may not be solid. Your license goes over, and nothing else goes over with it. Say exactly this when you hand it. I am providing my license. I prefer not to answer questions beyond providing my documents. Then stop talking. Same stop, same car, same officer. 2 outcomes. The wrong way. Jasmine is a teacher driving home to Georgia from a late evening at school. Officer pulls her over on a 2-lane road just after 9 at night. The window comes down. The officer says nothing yet. Jasmine says, "Hi, officer. Is something wrong? I do not think I was speeding. I have been very careful since I got my new car." Officer says, "License and registration, please." Jasmine says, "Of course, yes." Reaches for her glove box, then says, "I hope everything is okay with my registration. I renewed online last month. Sometimes those stickers take a while to arrive in the mail." Officer notes, driver immediately referenced possible registration issue. Driver appeared nervous. Driver volunteered information about recent renewal without being asked. He now has 3 things Jasmine handed him unprompted: her nervousness, a possible registration issue, and the fact that she knew about a potential documentation gap, all from her. Before he said a word beyond license and registration. The stop takes 22 minutes. His report references Jasmine's voluntary statements as contributing to the extension of the stop. Now the right way. Same lights, same road, same officer. But this time Jasmine watched this video. Officer approaches the window. Jasmine keeps her hands on the wheel. Before reaching for anything, she says clearly and calmly, "What is the reason for this stop?" Officer says, "Your rear tail light appears to be out." Jasmine says, "I understand. Here is my license and registration." She reaches for them, after announcing it. "My registration is in the glove box. May I reach for it?" Officer says, "Go ahead." She hands both over, says nothing else. Officer runs her information, returns to the window, hands back the documents with a fix-it notice. Officer says, "While I have you, where are you headed tonight?" Jasmine says, "I prefer to keep that private. Am I free to go?" Officer says, "Yes, ma'am. Get that light fixed." Jasmine drives away, records a voice memo at the next block. Time, location, badge number from the notice, the stated reason for the stop, what she said, what she was asked, what she refused. 60 seconds of audio that protects everything if she ever needs it. 2 scenarios, same stop, same driver. The only difference was knowledge. 1 word on state law before we close. Every state requires a driver to produce their license, registration, and proof of insurance when requested during a lawful traffic stop. That is universal. In stop and identify states, including Texas, Nevada, Colorado, and others, you are required to identify yourself by name when an officer asks during a lawful detention. That obligation exists alongside, not instead of, your right to ask the reason for the stop. California's Assembly Bill 2773 requires officers to state the reason for a stop before questioning or searching the vehicle. If you are in California, that statement is not just a courtesy, it is a legal requirement. In all states, knowing the reason for the stop is not the same as consenting to additional investigation beyond that reason. The 2 are separate. Knowing why you were stopped does not open your car. It does not obligate you to answer questions about your evening. It simply establishes, on record from the first moment, what the officer said was the legal basis for your detention. That record is yours. Protect it from the first word. The protection only works when everything you are doing is completely lawful in the state you are in. Let me bring everything together so it sticks. You are legally required to show your license. That is not changing. What changes is the sequence. Before your license moves, say this: "What is the reason for this stop?" When the officer states the reason, then produce your documents. Announce every reach before you make it. Hand over license, registration, insurance. Say nothing else. When the officer asks where you are going, say this: "I prefer to keep that private." When the officer asks questions that go beyond the stated reason, say this: "I prefer not to answer questions beyond providing my documents." When the stop is over, say this: "Am I free to go?" Then record a voice memo immediately. Everything. Before you move. 4 words at the start of the stop. That is the whole video. What is the reason for this stop? 4 words that put the legal justification on record before anything else exists in that encounter. Most people will never know to ask it. They will hand over their license on reflex and answer every question that follows because they think that is what cooperation looks like. Cooperation does not require self-incrimination. And knowing the reason for your own detention is not resistance. It is the Fourth Amendment working exactly the way it was written to work. The next video covers a 2026 court ruling that changed what officers can legally do in the first 30 seconds of a stop, before you have had a chance to say anything at all. Subscribe so you do not miss it. If this video helped you, hit like right now. And tell me in the comments, did you know you had the right to ask this question? Yes or no? I read every single one. Most people learn this the hard way. You just learned it the right way. That difference matters more than you know. This video is for educational purposes about your legal rights. It is not legal advice for your specific situation. Laws vary by state. If you are facing a legal issue, consult a qualified attorney in your jurisdiction.